Hello and welcome to this webinar which has this title: What changes will be brought into the court process under the Insolvency England and Wales Rules 2016. In this webinar I'll refer to those rules as the new rules or simply the insolvency rules. My name is Stefan Ramel. I am a practicing barrister at Guildhall Chambers and I practice in insolvency and commercial law. Let me start with some basics. The new rules come into force on the 6th of April 2017, and they represent, for insolvency practitioners, the single biggest change to the procedure which governs insolvency proceedings for approximately 40 years. The new rules provide that all rules on court processes are now contained in Part 12, with one small caveat, which is that Part 1, specifically Rule 1.35, sets out certain minimum requirements for insolvency applications. It is important to appreciate that the new rules come with transitional provisions. They are contained in Schedule 2, and in particular paragraph 14. What they provide is that if a court is seized of insolvency proceedings, the old rules will continue to apply. Now, a court is seized provided that the proceedings are ongoing, and ceases to be seized if it makes an order which has the effect of determining the action, or in the case of bankruptcy petitions or winding up petitions, it makes a bankruptcy or winding up order, or dismisses the petition, or the petition is withdrawn. Now, it is also important to appreciate that as regards appeals or reviews of decisions, even of proceedings which were started before the new rules come into force, that an appeal will be governed by the new Part 12. Now, it's fair to say, by way of overall comment on the new Part 12, that the rules do not revolutionise or substantially alter the procedure that will apply in insolvency proceedings. To the extent that there is one big change to single out of which practitioners should be aware, it is that whilst the old rules provided for court forms which were prescribed, the new rules do not. Those have been abolished. However, in the week before the new rules are implemented, the court service has started to produce standard court forms for use by practitioners. There is one which is relevant to this webinar, and it is the new form which, as at the date of recording this webinar, is known as IAA, and it is a form of application notice. Now, so far as the scope of Part 12 is concerned, there is little change to the position which prevailed under the old rules. All applications are governed by Part 12, except an application for an administration order, a winding up petition, a creditor's bankruptcy petition. Those are governed by separate parts of the new rules. As before, the civil procedure rules continue to apply in insolvency cases, except where those rules are inconsistent with the new rules. Again, as before, insolvency proceedings are treated as allocated to the multi-track. The new rules also provide, as did the old, that all applications are to be made in open court. Now, Chapter 3 of Part 12 contains rules of general application as regards applications under the new rules. Chapter 4, it's worthy of note, contains rules which are specific to certain types of applications. Chapter 4 is organised in subdivisions, of which there are 3. Subdivision A deals with applications under Section 176A of the Insolvency Act, that is, applications which relate to the prescribed part. Subdivider B deals with applications for information and examinations under Sections 236 and 366 of the Insolvency Act. And finally, the last part of Chapter 4 deals with applications in respect of persons who are unable to manage their affairs or who otherwise lack capacity. Now, so far as service of evidence by the applicant and the respondent in relation to an application is concerned, the position under the new rules is as it was under the old rules. The applicant's evidence must be served 14 days before the hearing, and the respondent's not less than 5 days before the hearing. As was the position under the old rules, the new rules also make provision in Chapter 7 of Part 12 for a court file. There is a right of inspection of that file for the office holder, for the Secretary of State and for a creditor, and if it's a company insolvency, for the directors or members, and if it's a bankruptcy, for the bankrupt as appropriate. It is possible for others to apply to inspect the court file, but that must be done with a view to obtaining the permission of the court. And of course, all of those parties, to the extent they are able to access the court file, can take copies, but will be required to pay a copying charge. Now, it is possible on an application to restrict access to either the entire court file or parts of the court file. That is still provided for under the new rules. Chapter 8, you will find detailed rules as regards costs in insolvency proceedings. And so far as appeals and reviews, the rules are now contained in Chapter 10. And they track the position under the civil procedure rules. Now, for example, an appeal from a district judge goes to a High Court judge or a registrar in bankruptcy of the High Court. An appeal from a circuit judge or a chancery master or a registrar or a district judge sitting in a district registry goes to the High Court, a High Court judge. There is still a requirement for obtaining permission to appeal, and as was the position before in corporate insolvency, the courts exercising jurisdiction in relation to parts 1 to 7 of the Insolvency Act can review, rescind and vary any decision. What was known as the formal defects rule, which used to be found in Rule 7.55, is now found in Rule 12.64, with, to my mind at least, no material alterations. Now, in terms of choosing the court in which to make your application, in the case of company cases, and if the county court has jurisdiction to hear the case, then it is the hearing centre of the county court in which the company's registered office is situated. And for that, you look at Rule 12.3. Now, there is a caveat to that, which is that by Schedule 6, there is a list of hearing centres in respect of which there is an alternative court for proceedings to be brought. Let me give you 2 examples. If a company's registered office is in Carmarthen, Schedule 6 to the rules lists Cardiff as an alternative hearing centre, so the proceedings would have to be commenced in Cardiff. If the registered office is in Coventry, then the proceedings must be commenced in Birmingham. Now, as regards personal cases, if the proceedings are allocated by the rules to the London Insolvency District, and for that one looks at Rule 12.5, then they have to be commenced in the County Court at Central London. That is the Thomas More Building in the Royal Courts of Justice. If not allocated to the London Insolvency District, then they have to be in the hearing centre determined in accordance with the rules, unless, as in the case of corporate insolvency, Schedule 6 provides for a different hearing centre. Making an application is done by filing the application with the court, and that's Rule 12.7. Let me introduce a further word of warning. As from the 25th of April 2017, e-filing will become mandatory in the Bankruptcy and Companies Court. There is a website which practitioners can find by using a search engine, but the web address is as follows. It is www.ce-file.uk. The website requires a user to register, and after the user has registered, they will be able to file documents electronically. According to the website, the courts at the Thomas More Building and the Royal Courts of Justice will have IT facilities and scanning facilities for litigants who do not have access to IT facilities. It's still necessary, as it was before, to pay court fees, and they are set out in the Court Fee Service Fee Form leaflet EX50, and that sets out all the fees which a litigant will expect to pay. So, for example, presenting a bankruptcy petition or a winding up petition, or in fact any other type of petition, The fee seems to at the moment be £280. The fee for an application on notice is £155. An application by consent without notice attracts a fee of £50. In some cases, because insolvency proceedings are allocated to the multi-track, it will also be necessary to pay a hearing fee. Thank you very much for listening. That covers all the major changes to the court process under the new insolvency rules.